Well, hey folks, I'm back with another discussion video lecture for the second part that I want to talk to you about, and that's balancing values in criminal procedure. And you could probably benefit by looking at your PowerPoints. I'd advise you to read your textbook, and then also consider some cases that we're going to be working on. In this particular area that we talk about balancing values, we're talking about the difference between community security and individual autonomy. Now that's put a lot of different ways. I like to call it the difference between safety and freedom. So in other words, freedom is the freedom to be who you want, do what you want, go where you want. And kind of reminds me of that Miley Cyrus song, you know. But anyway, on the other hand, security is like safety. Really, in a way, it seems facetious and it seems silly, but take a teenager, for example, like a Miley Cyrus or somebody like that. You know, if you're doing all kind of crazy things, trying drugs, running all around, breaking the law, it's unsafe. But, you know, everybody wants to be free. They want to do their own thing. And so the question is, just how much freedom should we have in relation to how much safety and security do we need? And so when we get into this, we have some simple things, and that is, you know, your life and your property. So a lot of people want their lives to be secure and safe, and it's understandable. Other people will risk their life in order to protect their friends and their family. And this is your police, your firefighters, and your military. And so in these different situations, there's higher levels of discipline and less freedom. And so if we take, for example, a case that I want to touch on this time, it's the case of Mapp versus Ohio. Now, Mapp versus Ohio was resolved around 1960. It actually started before that, and it ran through 1960, and then the final decision was rendered in 1961. The full case citation, and this is something that you need to understand, is 367 U.S. Reporter 643. So if you're going to cite this case, you would put Mapp, M-A-P-P, versus Ohio, the state of Ohio, and then you would put 367 U.S., both in caps, and then the page number, which is 643, and then the ending would be the date, which would be 1961, and that would be in parentheses. And we'll see more of this. I'll put some drawings up and some different things to try to show you, you know, what's the best way to cite a case, and we'll work on that some together. But the important thing about Mapp was Dorley Mapp lived in the 60s, and it was kind of an explosive time in Cleveland. This is a funny case because there's a lot of little side things going on here. She had a man living with her. It was allegedly that this guy was a renter. But there's some people that say that they had an ongoing relationship. Well, at any rate, he was gone. He had moved out. Well, these police officers came to her house and wanted to search for this guy because they thought he might be a bomb maker, some kind of a bad person that was out to commit some crimes. Well, they tried to force their way into Dorley Mapp's house, and she said no. Only with a warrant. I called my lawyer and he said that you're supposed to have a warrant. So the police officer left and they were gone for about an hour. Well, then the police came back, as they often want to do, and they gave her a blank sheet of paper. She grabbed it and stuck it in her brassiere. Well, they reached down into her bra and took that paper back out. It's interesting because in the facts of the case, that's the only time a warrant is ever mentioned. There was no search warrant. That's obviously easily understood when you see that it's never mentioned again. And they had just tried to fake their way to get in the door, and they did. And once inside, they started searching around. Of course, they found no evidence of this guy, but they did find a little bit of what they called pornographic material. Well, now, at the time, it's hard to tell what that really was. It could have been a copy of GQ magazine, for example. It's very doubtful if it was the kind of thing we think of as pornography today. But anyway, they shifted their attention. Since they couldn't find the man, they couldn't find any bomb-making material, they filed charges against Dawalt Mapp because she would not cooperate with police. She tried to insist on her rights. And so Dawalt Mapp, she appealed her conviction after the police filed the charges, and the court just kind of brushed off her arguments that this was an illegal search of her home without a warrant. And it went up to the Ohio Supreme Court, and the Ohio Supreme Court also said, oh, there's really nothing to this. If they didn't molest her in any way, they didn't beat her, for example, they didn't knock her down when they pulled that piece of paper out of her bra. And so they all said, the state of Ohio said, well, yeah, this evidence is okay, we can use this evidence. Well, the United States Supreme Court developed a different perspective on this, and they just said, hey, this is a violation of the Fourth Amendment. They forced their way in her house. And it's also a violation of what we call the Due Process Clause of the 14th Amendment, because the 14th Amendment says that any laws that apply to the federal government apply to the states in equal manner. And so Mapp is considered a very basic preliminary introduction to the idea that we do have the right to be secure in our homes. There's an ancient common law standard called the Castle Doctrine, which means we all have the right to be in charge of our own castle, which is our home. And so this has opened up a can of worms in future cases. We'll be looking at other cases, and we'll be reporting on what developed after Mapp versus Ohio. But it's an important thing to understand this early case and get a sense of this whole thing, is that generally under the Fourth Amendment, as applied by the 14th Amendment, no police officer, FBI agent, nobody can come in your house without a search warrant. Now, this question comes up again, though, in some other areas. What about a building inspector? What about a child protection services worker from the welfare department? And so a number of these different things, you have nuisance abatement officers, you have all these different people. Do they have to have a warrant? And so there needs to be some understanding of this. Do you need some kind of a court order or a warrant to enter into anybody's home under certain circumstances? Let me ask you a question. This is a good one to bring up in the discussion. What if there's a fire? Can the fireman come in your home to put out your fire? He doesn't have a warrant after all. And so this all has to be sorted out. And so you're going to want to work on this in this class, and you're going to want to look this up on LexisNexis. You're going to want to look it up in Shepard's and try to find other cases that apply Mapp versus Ohio. Okay, well, let's throw ourselves into this. This is our first big project. Get started on it. If you have questions, ask in the general discussion, talk to your group members, and check with me on just how to do LexisNexis, how to do Shepard's. And we're starting off really with basically an easy class because of Mapp versus Ohio, a very well-known case. So enjoy. We'll be back with another case very soon.